Good morning, everyone. It's 1 o'clock, so I think we can start with the session. So before we start with the topics, there's just two housekeeping things that I would like to mention from Betty. She said that she circulated the Q&A yesterday, and if any of you haven't received it, please just email her and let her know. And then we know that some of you had issues with your connection yesterday, and just to accommodate you, please email Betty and let her know if you are interested in having another opportunity to listen to the session, and then she can communicate with you a time that's suitable for a further opportunity to listen to this session. Okay. And then the last thing, we just changed the sequencing of the topics on slides slightly. So we'll circulate the updated slides to Betty after the session so that she can share it with every one of you. So yeah, I think then we're ready to start today's session. So the first topic we'll discuss today is possession of the site and early takeover. Firstly, we'll look at the difference between access to site and possession of the site. So generally, the employer is required to hand over possession of the site to the contractor to enable the contractor to commence with the work. That's a general obligation that the employer has. And in doing so, the risk of the loss or damage to the site and the work is assumed by the contractor. So the contractor then takes control of the site, and the contractor is at risk for the site and the works during that period. So in terms of common law, no one may enter or access the site without the authority of the contractor. And in terms of the provisions of contract, this common law position is altered in most construction contracts, providing that the employer and his agents and sometimes the lenders are allowed to access or enter the site and inspect the works. So just to mention a few general obligations with regards to the provision of access and possession of site is that one should always consider that the right may not be non-exclusive to the contractor. It's usually shared with other contractors or subcontractors. We've mentioned that briefly yesterday. So as a result, there should generally be a cooperation obligation between the contractors on site. Access to site and possession of site generally entails for the contractor to establish itself on site by signage and establishing site offices. And as I've said, the contractor then has control of the site. It includes then, it also needs to provide for the necessary security and safety on the site. From our experience, what we usually see with sites that's not fenced off is that, for example, if you have a railway line, which is your site, and the railway line is about 160 kilometers, it's difficult to give access of the site as a whole. So we've seen in instances like that the right of access is provided in parts. There are also other practical challenges with sites such as a railway line, because even though the handover occurs sectionally, there's no sectional completion date. It's always a challenge to negotiate who's responsible for security and health and safety. So there must be some fluidity with obtaining and keeping the site access. Okay, then we're going to look at takeover of site. So taking over normally occurs when the contractual requirements for works to be considered complete have been satisfied, and each contract may have its own requirements. Contracts should clearly specify what needs to be done in order for the works to be accepted by the employer. Although the specific requirements will depend on the nature of the project, typical requirements include that the works can be used for the intended purpose, notwithstanding the existence of minor defects. And all tests on completion have been passed, and all necessary approvals for the works to be used have been obtained. So even though the works have not achieved the state to be taken over, parties should be aware that the works may be deemed to have been taken over in certain circumstances. So an example of that is in subclause 10.2 of the FIDIC Red Book, the 1999 edition. There it provides that works will be deemed to have been taken over in the event that they are used or occupied by the employer prior to the issue of a taking over certificate. This is because such use of or occupation of the works by an employer demonstrates adequate completion of the facility, and the employer's use or occupation of the works may cause damage or disruption for which it would be unreasonable to hold the contractor liable. There's obviously a shift in obligations when the employer takes over the work. So the possession and risk of in the works is upon takeover transferred from the contractor to the employer. And it is therefore vital that the employer ensures that it has the adequate insurance for the works upon the date that it takes over the works. In some instances, you also find that there are early takeover of the site by the employer, and that is usually in circumstances where it becomes commercially important for the employer to start with commercial activities and to use the facility, even though the facility does not satisfy the contractual requirements for it to be taken over. So in that situation, the employer could consider circumventing the risk of the whole of the works by being deemed to have been taken over by dividing the works into sections and only taking over a particular section. If that approach is not viable, the employer could also consider using express qualifications to the effect that it uses the facility as a temporary measure, and which should then not be deemed to constitute taking over on account of specified defects or items that are incomplete. Then I will consider liens. So the question I pose is, when can a lien be exercised? The common law right which entitles a contractor to remain in possession of the property of his employer as security for payment in respect of the work performed on such property. Generally, contractors are required by the employer to agree to an express waiver of rights to the common law lien. So the different types of lien you find is enrichment lien and debtor creditor lien. Enrichment lien enables a possessor to claim expenses for necessary and useful improvements and to retain the property until the claim for compensation has been satisfied. This lien is dependent upon an underlying enrichment claim. Then a debtor creditor lien arises from a contract, and that is when a payment is due, owing, and payable, the contractor can exercise that lien against the employer. The effectiveness of this lien is that the lien holder may retain the property as against the other contract party and not against any other third parties who may have a right in the property. And that lien can be held until the holder has been paid the contract price. Okay, so then we can move on to the next topic of discussion, which is fit for purpose and the standards of a reasonable and prudent contractor, which is a principle that you find in most, that's legislated for in most construction contracts. The common law concept of that is that fitness for purpose obligation could well be implied in construction contracts if it's not specifically legislated for in the construction contract. Typically, the level of skill and care used by the contractor doesn't matter. So no matter what the level of effort and expenditure is that the contractor has applied, it is the fitness for purpose in the relevant sense that is important and for which the contractor will be liable. Employers tend to prefer the fitness for purpose obligations as they are perceived to mitigate design and defect risk on high value projects, particularly where performance is important. It is accepted in South Africa that in terms of construction contract, works must be completed in such a way that it's fit for the purposes for which it was intended. For this to apply more generally, however, the intended purpose must be agreed upon, and the contractor must be aware for which purpose the employer is using the product. Although fitness for purpose style obligations are often implied by law, most international model forms of construction contracts seek to introduce a more consistent transnational framework for legal responsibility for the functionality of the works. So, for example, the current main suite 30 contracts contain an express promise on the part of the contractor. And I'm going to read it out to you. It states that the contractor shall execute the works in accordance with the contract. When completed, the works shall be fit for the purposes for which they are intended, as defined and described in employer's requirements, or where no purposes are so defined and described, fit for their ordinary purposes. Okay, and then we're going to move on to the reasonable man test and the standards of performance at which it is measured against. So in South Africa, it is the reasonable man test is used when one is faced with a question of liability or obligation, including implied warranty. So in the context, it is implied that a contractor, when executing works, would act and perform in a manner that is reasonable of its caliber and expertise. In addition, there are a number of cases in South Africa where comments and promises made during the negotiations of contract were held to be warranties, even though they were not written in the contract. So the test is then whether the other party is induced by the promise about the work that it would be held to constitute a warranty. So the reasonable man test cannot be contracted out of. A contractor will always be required to act with reasonable skill and care. It is accepted that parties will enter into agreements in good faith, and as such, a clause that a contractor does not have the reasonable skill and care would be against public policy. A standard disclaimer for fit for purpose test and other implied warranties that you can find in the contracts is the following: except as specifically provided in this agreement, the contractor makes no representation or warranties or guarantees in respect of the works, including but not limited to quality, suitability, fitness for particular purpose or otherwise, whether expressed or implied. So the contractor shall not be liable for any representation or warranties or guarantees not expressly provided for in this agreement. Okay, so the next topic we will discuss is certification. Firstly, we can just have a look at an example of a payment certificate. And I would like to highlight some of the items set out in what that you will typically find in a payment certificate. So it will identify the parties that are involved, details of the works of the site, and when the payment certificate is issued or the date of the valuation. Then it will set out the value of the works that's executed together with the materials. And then I'm not going to go through each and every item. You can look at it at your own time, but then ultimately there's a gross amount that's certified. And more importantly for me is to look at what is then deducted from that amount, and that is the expenses and loss, the penalties, and the damages. All those items are set out in a recovery statement, which is attached to the payment certificate, and those are essentially the employer's claims. And then ultimately, when that's deducted, you get the certified amount that's due for payment to the contractor. The payment certificate will then be signed by the principal agent or the employer's agent with a date. So this payment certificate is particularly it refers to a certificate number at the top, and this is therefore an interim payment certificate. So we've gone through all the items that you could find in such a payment certificate, and then when it's signed by the employer, the principal agent or the employer's agent, it is considered as the determination of the amount that's due either to the contractor or the employer. So in consideration of interim payment regimes, we've discussed this briefly yesterday as well, that it could be milestone payments, monthly payments against estimates or measurement of work, and then absent interim payment certificates, it will be regulated by common law. So under common law, the contractor is not entitled to any payment until it has completed the work in its entirety. And interim payments are actually considered as advance payments on the sum which is to be paid out when the work is finally complete. And as we've discussed yesterday, that the purpose of the interim payment certificate is just to support the contractor with cash flow and also to ensure that subcontractors receive payment for the works that it has performed. A final payment certificate is then issued upon completion of the works. Generally, that is a consultative process. The employer's agent would sit with the employer and the contractor and consider the values that are claimed in terms of the final payment certificate before the employer's agent will then determine the value that is ultimately due. So in this regard, there are authorities that actually speaks towards the effect of an interim and final payment certificate. So generally, a certificate is considered to be a liquid document, but the court's decisions are not harmonious on whether an interim payment certificate, as opposed to a final one, can support an action for provisional sentence. So even so, an interim certificate is not conclusive as to the items of work performed on the value or the amount so certified. So it is not a final settlement in respect of the items of the work certified. All the matters may be adjusted in a subsequent certificate for a variety of reasons. So because of a more exact measurement and the actual work done and material supplied, the amount certified in particular may be readjusted or even overridden. So it's therefore fair to say that the amount certified in an interim payment certificate is merely provisional and is always subject to correction. Then the court's approach, I've mentioned a few case law authorities that you can look at. I'm not going to go through this in detail now, but we will share that with the booklet that we will share when all the topics have been discussed at the end. Move on to the next topic.
Okay, so moving on to defects. Sorry, I'm just finishing off a comment. All right, so a defect is basically work that was not performed in accordance with the requirements of the contract. And you get minor and you get major defects. So what is considered a major defect is any defect that would render the work unusable for its intended purpose or renders the work unsafe to use. And the employer will not accept handover of a site or a project where there are major defects in the work. Minor defects do not render the work unusable, but it is nevertheless something that does where the work does not comply with specifications or requirements. So it doesn't ordinarily affect final completion and handover to the employer because these types of defects typically get dealt with and remedied after handover during the defects notification period. There is an implied warranty that the contractor will provide a deliverable that is free from any defects. So warranty periods can be shortened, they can be extended, or they can be completely excluded by the agreement. And this is usually in the form of a defects notification period, which in some contracts is called a defects liability period, or a limitation of liability clause. So there's no specific starting point for a warranty period. Once there's a defect, the innocent party must prove that the defect is a breach of the common law warranty and that a contractual nexus existed between the parties, if the claim is contractual, or that the innocent party must prove that there is fault on the part of the contractor which resulted in the damages if it's a delictual claim. Unless the parties agree to a specific evergreen warranty, no warranty would be an evergreen warranty, and any claims for breach of warranty would be subject to the laws of prescription, which is generally 3 years from the date it became or ought to have become known, as set out in the Prescription Act. We then deal with what is a patent defect and a latent defect. So the patent defect is any defect that's obvious to the naked eye upon inspection. So where the employer has inspected the deliverable and at the time that the inspection takes place, it would be able to see that defect and it can immediately notify that there is that defect. A latent defect are defects or faults which existed but were not apparent at the time of completion or delivery. It could also be defects that only occur a bit later on, and it can't be identified by a reasonable and thorough inspection at the time of handover. It also has to be a defect that either destroys or substantially impairs the use or the effectiveness of the purpose for which it was done or provided. Then a contractor's obligation to remedy defects before completion, so before there's handover, that is generally regulated in the contracts through an employer's right to inspect and notify defects as they become aware of it. So the standard form contracts have specific provisions for inspection of the works, and those works or those defects then need to be remedied within a reasonable time given by the employer. In terms of the common law, there's no limited period within which a claim in relation to latent defects may be made, as long as the requirements of the Prescription Act are complied with. Where, however, there is a contractual provision specifying a latent defect period, the employer's right to claim would be limited to that provision. So if the contract is silent, the innocent party can just notify the other party to remedy the defect at any time when the defect arises, and without such a notice being in any specific form, it can grant a reasonable opportunity to replace, to repay, and to rectify. And typically it is within the contractor's discretion how to replace, repay, or rectify, or not repay, replace or rectify, as long as the end product then meets the purpose for what it was intended. So in terms of being a prerequisite for final completion, although a contractor can achieve practical completion or take over, handover as we call it, with minor defects remaining, the final completion will only be certified once the defects have been rectified. So that would include minor defects as well. So you'll have a period between practical completion when the employer starts to use the works and final completion when the project is set to now be complete. Then the contractual obligation to remedy defects after completion, as we said, that's regulated by a defects notification or liability period. And there are different interpretations on the effect of a DNP. So it may be argued that a defect notification period extinguishes all the common law remedies for all defects, latent and patent, after the expiry of a period. It can also be argued that the defect notification period only creates the obligation to put the defect right and not liability for the defect in general, beyond the obligation to actually remedy the defect. And then it could potentially be argued that the common law remedy to claim damages is not extinguished, since all that the defect notification period does is it limits the time frame in which the employer has a right to notify and compel the contractor to return to site and to make good the defects at the contractor's own expense. So this would mean that after the expiry of the defect notification period, the employer no longer has the right to compel the contractor to make good defects that were notified within the specified period, but that the employer may still seek recourse in a damages claim against the contractor. So this means that insofar as the contract does not prohibit this, the contractor may still be liable for latent defects after the expiry of the DNP based on common law damages, where the employer corrects the defects and then claims the expenses. These interpretations are all things that a court would look at based on the contract terms and the specific facts surrounding a particular dispute. So defects liability provisions are not an exclusive remedy unless the contract clearly states that there are no other remedies available under the contract. So the contractor will remain liable for a breach of contract. So clear drafting, given all that we've now just said, clear drafting is absolutely required to ensure that the party's true intention is given effect to in terms of DNP. Then access to site in order to remedy the defects. A contractor has a right to return to the site during the DNP in order to remedy defects at its own cost. For the contractor, that would likely be more economical and efficient than to pay the costs of another contractor hired by the employer. So if there is a contractual right for the contractor to rectify defects, and the employer either does not notify the contractor that rectification is needed or refuses access to the site, then the employer may be in breach of contract. However, the employer will still have a claim for the cost of rectifying the defects, but the claim is likely to be limited to the amount it would have cost the contractor to carry out the works itself. So it will not be able, the employer will not be able to claim for remedial works or working methods found not to have been strictly necessary. It will also then not be able to claim for increased costs. If there's no contractual provision, the contractor doesn't have a right to return to the site to rectify defects. However, the employer's general duty to mitigate its losses before making a claim by taking reasonable steps to avoid or reduce them means that its damages may be limited if it refuses to allow the contractor to rectify the defects itself, especially where the defects are relatively minor. The relevant test is whether the employer has failed to act reasonably. If the contractor's original work was of a low standard, then the employer can obviously argue that it was reasonable to refuse to let the same contractor return to the site. In deciding whether it's reasonable to refuse to let a contractor return to site, the court can take into account a breakdown in the relationship between the parties as well. So a guilty party must rectify the defect within a reasonable period. If it fails to do so, then the innocent party may do the work itself and claim rectification costs and damages, or employ another contractor or service provider to remedy the defect and then claim the rectification costs and damages from the guilty party. So in instances where the employer has retained a cash sum as security, like retention, it may deduct the cost of remedial works and damages from such a cash sum retained. Further, where a performance guarantee is still valid and enforceable, the employer may call for payment under that guarantee to cover the costs and the damages. In terms of common law, if a guilty party does not remedy the defect, then the innocent party must institute legal proceedings within 3 years from becoming aware of the defect, or when it reasonably ought to have become aware, else it will lose its right to claim. Any obligation to remedy under the common law is based on a causal link between the damage or the costs and the event itself. So if an item has been replaced and or repaired, there would be an implied warranty that such a replacement or reparation is in good order. And if the replaced or repaired item then becomes defective later on, the common law prescription period, or not the common, the prescription period in terms of the act, will start running anew. Where there's a dispute, whether it's a defect or a defect, whether there's a dispute, whether it's a defect for which the contractor is liable or not, will have to be dealt with as provided for in the contract. So if it's an ADR provision, it must go to ADR, otherwise it's going to court. The transfer of risks or defects, including the liability for defects in works that were taken over by third-party contractors, is dealt with as follows. A party claiming for a defect must prove that the work of the contractor is in fact the cause of the defect arising, so that root cause analysis, as we call it, and wear and tear cannot be claimed as a defect. So an employer who takes over the work to operate and maintain the work is required to do so in terms of the relevant manuals and any prescribed documents. If they do not do that, it could impact the employer's ability to either prove a defect, or it can impact on their ability to claim for the full damage caused by the defect. Where the contractor has specifically prescribed instructions for how to operate and maintain the work, the employer is obliged to comply with those specific instructions. Where the contractor did not prescribe the instructions, the employer would be required to reasonably maintain and operate the work within the reasonable man test, which could include an obligation not to misuse or abuse the work for the deliverable. Where the contractor is responsible for operating and maintaining the work itself once the project is completed, it would take on the liability for defects for a period agreed specifically between the parties, alternatively for the common law period. All right, so just to recap, in terms of the prescription of a claim for defective work, it will either be regulated through the Prescription Act. Alternatively, it can be limited or extended through specific contractual clauses. Okay, we're going to move over to variation orders.
Okay, so firstly, we will consider what constitutes a variation order. As you all maybe already know, it frequently happens during the course of the building contract, construction projects, that there are changes to either designs or any other reason where there are some variations to what was initially agreed, and that the contractor is then required to do additional work which wasn't necessarily specified when the contract was concluded. So to be regarded, one needs to keep in mind that to be regarded as extra or additional works, the work must firstly not be expressly or implicitly included in the contract. So additional work, which although not actually contemplated by the parties, naturally flows from the work initially contracted for, and which during the progress of the construction, the architect might order to be done. So in terms of variation orders, we generally see that project managers or the employer's agent have the authority to issue variation orders. The process or the types of variation orders that you generally find in construction contracts is either through a request for quotation or an instruction to perform a variation order. So we'll firstly consider a request for a quotation. The employer shall, before it issues a instruction for a variation order, provide a notice or a request to the contractor to provide it with a quote to perform additional work. The contractor shall then respond to the notice and submit its proposal. And that proposal will obviously include pricing and the details of the scope, the additional work that needs to be performed. The employer can then either consent to the proposal submitted by the contractor, or it can just disregard the proposal. Once the employer consents to the proposal, it constitutes a variation order. If it doesn't consent, the contractor may, in certain circumstances, or if the contract legislate for it, claim payment of costs in relation to the submission or the proposal it had to make. And then moving on to when a variation is instructed by the employer. If the instruction does not state that it's a variation order, but the contractor considers it to be potentially a variation order, it is important for the contractor to confirm and verify that with the employer before it commences with any of the works. If there's no response by the employer within generally a reasonable period, it would be 7 days as it is provided for in the standard contract, then the instruction would be deemed to be revoked. So the contractor would then not perform the works in terms of that instruction. If there's an instruction and the contractor proceeds with the execution of the variation, it shall submit to the employer's agent detailed particulars, for example, description of the very work, a program for the execution of that work, and then obviously also the adjustment that would be necessary to the contract price, the additional cost that will be incurred. The engineer will then consider that claim and issue a determination so that there could be an adjustment to the contract price. So generally the reasons for a variation order is when there are additional work that needs to be performed, if there are changes to the scope of work, or in certain instances where there is omission of work to the original scope of work agreed. So where a building contract makes provision for the issuing of a variation order by the employer or the principal agent or the engineer, whereby the employer may omit certain scope of work, any omission so ordered have to be a genuine omission in the sense that the employer has decided not to proceed with a particular item of work. That is very important. So if a contractual provision cannot be used to omit items in respect of which the contractor has tendered, and then to award that same scope of work to another contractor, that would amount to a breach of contract on the part of the employer. Then contractor's obligation to comply with a variation order. Generally, the contractors have to comply with the variation order, whether it's oral or in writing. The exception is that contractors gives notice that it cannot perform a particular variation order. In certain instances, it can be as a result of the varied work was unforeseeable, having regard to the scope and nature of the works, cannot obtain the goods to perform the variation, or the additional work may adversely affect the contractor's ability to comply with health and safety obligation, or it adversely impact on the achievement of performance guarantees, or another reason could be that it adversely affects the contractor's obligation to complete the works to be fit for its intended purposes. Then considering the remuneration or the contractor's entitlement to remuneration, that would particularly be prescribed by the contract. If it is not prescribed by the contract, then the contractor would be entitled to reasonable remuneration. And one should always keep in mind that your entitlement to remuneration is not automatic. The contractor will always be obliged to comply with the claim process under the contract. That would then be followed by a determination process of the costs. So often a clause to the effect that there were extra work. Then the engineer will consider that claim, and the cost will usually be expressed as a percentage of the quantity listed in the bill of quantities. Then determination of costs further is such clause usually recognizes that major variations may imply change in the method of operation or source of supply and make it unreasonable to apply to the tendered rate. Then we're going to consider the next topic, that is claims and determinations. So The nature of claims that you generally find under construction contracts relates to adjustments to the program as a result of delays, and then the associated costs, additional costs. So events that the employer is usually entitled to claim for under construction contracts could be related to delay, liquidated damages, and extension of the defects notification period. Events that contractors would generally be entitled to relief for is if its performance of its obligations is hindered, prevented, or delayed by any event that falls outside its control. In construction contracts, those events usually include force majeure events, access to site, or change in law. Then one needs to consider the process of any claims. That's very important for purposes of enforcing one's entitlement to relief. The claims process generally includes the delivery of a notice of your claim, together with particulars of claim, and then that would be followed by the determination by the engineer or the employer's agent. So we're going to have a separate topic discussion on notices, but just briefly to touch on that, each of the standard forms of construction contracts provide for a specific procedure that the party should follow if either one of the parties believes that it's entitled to claim relief in terms of the contract. And generally the party that believes it is entitled to relief is required to deliver a notice and details of the claim within a specific period of time. Then in terms of particulars of claim, the particulars of claim will might also be subject to a time bar provision where it is submitted out of time. Particulars of claim need to show supporting evidence of the contractor's or the employer's claim, including the details on the quantum of its claim. Generally, that will also include a revised program of the works where the claim relates to an extension of time. Then moving on to determinations, which follows the submission of particulars of claim by the contractor or the employer. Determinations are generally issued by the employer or the employer's agent upon assessment of the particulars of claim. A determination for money is mostly given effect to in the next payment certificate through the inclusion of an additional sum. So you may have seen in the example that we looked at in a payment certificate, that generally allows for an item to be included where there is certifications of claim. Then a determination that relates to additional time is given effect by extending the date for completion and the acceptance of a revised program of works. It is extremely important, and I need to emphasize just from a dispute resolution perspective that for purposes of determinations and supporting your claim, its record keeping is essential, particularly updated programs that demonstrates the entitlement to extension of time, for example, and any other documents that could demonstrate your entitlement to claim for any events that caused delays to the progress of works. Okay, then I'm going to move on to specifically focus on the notices. So the purpose of notices is that besides being required to put the party in mora for non-performance of its obligation, the notice may be required when additional compensation or extension of time is claimed by a contractor due to events that may result in a breach of its performance. So it is also a tool to just to administer and manage the risks associated with risk events on the site. Notices may be classified in the following categories based on what you could see in the standard forms of contract. It can either be a simple obligation, a condition precedent, or a time barring provision. The consequences of failing to give notice will depend on the category of the notice in each case. So if there's non-compliance of a notice provision, which is a simple obligation, it will not necessarily have a cause to the contractor to forfeit any rights it may otherwise have had to its claim. However, if to the extent that the employer can show that it was prejudiced by some non-compliance and that as a consequence the contractor should not be granted the additional compensation or extension of time claimed, the contractor's claim will be reduced accordingly. So, for example, a clause that provides that in the event that the contractor encounters adverse subsurface conditions that may give rise to a claim for additional compensation and or extension of time, the contractor shall within 48 hours notify the engineer of such conditions in writing. So in terms of that example, you can see that where the contractor does not provide the notice and the particulars of claim, the employer may argue that had the required notice been given timeously, the engineer would have had the opportunity to alter the design or to deal with the adverse subsurface condition encountered, and leading to significantly reduced cost and minimum delay. So, as I've mentioned, it's a tool to administer the risks on site. A notice provision, which is a condition precedent, may be complied with before the relevant claim becomes ripe for consideration. So as an example would be the following wording in the contract is, in the event that the contractor considers that an engineer's instruction will cause additional expense for which it will require compensation, the contractor shall notify the engineer in writing prior to the executing of such instruction and of its intention to claim such additional expense. If no such notice is given by the contractor before he carries out the instruction, the engineer will be fully justified in believing that there will be no claim for the additional compensation. Such a clause is, however, not an absolute bar. To the extent that the contractor can demonstrate that the employer has not been prejudiced by the lack of a notice, the contractor may well succeed in claiming extra expenses which have been reasonably incurred. So a time-barring provision requires notice to be given within a certain specified time, failing which the entitlement to claim is extinguished, except for the circumstances that we've just explained above. So such clauses may be viewed as being draconian and as a consequence are interpreted strictly by our courts. So this means that in the event of there being an interpretation which will have less harsh consequences for the contractor, the court will prefer such interpretation. So an example of a time-barring clause would be in the event that the contractor incurs standing time as a result of any event defined herein as an employer's risk, the contractor shall, within 14 days of commencement of such event, give written notice to the engineer of any intention to claim compensation therefor. Failure to comply with this provision of this clause will cause the contractor to forfeit any entitlement it may have had to such compensation. The notice clause needs to be precise and unambiguous. So typically, you would see that a notice clause will include what the notice should look like, whether it can be sent via post, fax, email, along with the address, fax number, or email address, the information that the notice needs to contain, who it should be sent to, and the time limit for sending it. Our court's consideration of a valid notice is based on the substance and the content of the notice and not the form. We generally follow a cautious approach when issuing notices on behalf of our clients by applying the requirements as per the contract in terms of the form and the content. Then we're going to move on to the next topic.
Okay, so talking about a breach of contract, the obligations imposed by the terms of a contract are obviously meant to be performed, and if they're not performed at all, performed late, or performed in the wrong manner, the party on whom the duty of performance lay is said to have committed a breach of contract. So in a construction context, default which may culminate in breach can be categorized as follows. We have negative malperformance, positive malperformance, and anticipatory breach, which is also referred to as repudiation. So in terms of malperformance, negative malperformance consists in culpable failure to do something timelessly in a case where performance does not become impossible as a result of failure. It may be committed by either a debtor, in which case it's known as mora debitoris, i.e. it's the default of the debtor, or by a creditor, in which case it's known as mora creditoris, or a default by the creditor. Positive malperformance consists in conduct which does not comply with the content of one's contractual duties. It can take the form of doing something that you are bound not to do, or by performing in a defective or inadequate manner. Moreover, if the content of a contractual duty and the time of its performance are so closely interlinked that performance becomes impossible if it's not rendered timelessly, then the failure to render timeless performance amounts to a positive malperformance and not to a negative malperformance. So from the definitions, it's clear that the essential difference between negative and positive malperformance is that negative is where the defaulting party may still purge its default within the period given, whereas positive malperformance there will not be a possibility of the default being purged. When we talk about anticipatory breach, mostly it would be in the form of a repudiation, although we also sometimes see or deal with prevention of performance. But in short, an anticipatory breach consists in a positive renunciation of the contract or a prevention of its performance. And an anticipatory breach can be committed by either a debtor or a creditor. And we'll deal a bit later with repudiation and prevention of performance. All right. So the remedies that's available for breach of contract is very shortly basically a contract 101 specific performance. So this is where there's an order to perform a specified act or pay a specific sum of money in pursuance of a contractual or other obligation. And it is clear that a plaintiff is allowed to claim specific performance, and assuming a case is made that such claim will be granted. Let me just stop there. So it is clear that a plaintiff is allowed to claim for specific performance as a remedy for a breach. You can then also obviously have termination of the contract, which we have dealt with, and then you can have a claim for damages, which we'll extensively deal with in just a bit. The only thing I would like to mention in addition to this is a court will not readily grant an order for specific performance where it would operate unreasonably hardly on the defendant, or where the agreement giving rise to the claim would be unreasonable, or where the decree would produce injustice or be inequitable. So the remedy for specific performance is not unconditional. So although a court doesn't have a general power to relieve parties from the consequences of unreasonable conduct, it can take this into account when deciding whether or not to order specific performance. Okay. Joanna? Was it still me?
Yeah.
Oh, sorry. Now we're dealing with termination. Okay. Okay, so we have contractual grounds for termination and we have common law grounds for termination. Dealing first with the contract, where the contract stipulates specific grounds for termination, the parties are bound by those terms. And so they have to terminate the contract within the confines of those terms. A lex commissoria or a forfeiture clause is a stipulation conferring a right to terminate upon a breach of contract. So it confers a right to terminate upon the fulfillment of a condition. Once it's concluded that the breach committed is one that brings the forfeiture clause into operation, its seriousness is completely irrelevant. So it would be valid and enforceable strictly according to its terms. So that would typically be where, for instance, there's a clause stating that if you exceed the completion date or there's a delay of more than 100 days, then there's an entitlement to terminate by the employer. Okay, so in terms of common law, where there's no forfeiture clause, a party may only terminate on the common law principles, which is where the breach goes to the root of the contract, i.e. a material breach of an essential term, and a notice of rescission has been properly given. Alternatively, a contract can be terminated for repudiation if the repudiation is accepted by the innocent party. In the case of Singh versus McCarthy Retail, the court said the following: I perceive the correct approach to be as follows. The test, whether the innocent party is entitled to cancel the contract because of malperformance by the other in the absence of a lex commissoria, entails a value judgment by the court. It is essentially a balancing of competing interests, that of the innocent party claiming rescission and that of the party who committed the breach. The ultimate criterion must be one of treating both parties under the circumstances fairly, bearing in mind that rescission, rather than specific performance or damages, is the more radical remedy. Is the breach really so serious that it is fair to allow the innocent party to cancel the contract and undo all its consequences? All right, then termination obviously has got notice requirements. The standard form contracts set out very specific processes and notice requirements for termination. If these are not followed, then the termination can be unlawful and amount to a repudiation of the contract, which could then allow the other party to terminate the contract on their terms. Under the common law, a notice of breach should allow a reasonable period for rescission before a contract is terminated. Where there's a repudiation, there's no requirement for a notice. All that is required is an election to be made, i.e. whether the repudiation is accepted and there's a termination damages, or whether it's rejected and specific performance is claimed. Termination for convenience is a clause that we do see in some of the standard form contracts, where the parties may terminate for any reason on reasonable notice, and that type of termination usually comes without the right to claim damages by either party. The remedies for termination, again, would be contractual remedies. Those depend based on what contract you're using. The standard forms set out very specific heads of claim for an employer termination and very specific heads of claim for a contractor termination separately. Under the common law, your remedy is very simply damages. Okay, final payment and handover. Once there is a termination, the employer must take possession of the site and the project, and all further risk transfers to the employer, subject thereto that the contractor will remain liable for defects. The only requirement or precursor to this is that the contractor has to make the site safe before it hands it over to the employer, and that's just in terms of normal health and safety rules. Final payment is then due to the contractor, and it must be calculated in accordance with the contract provisions based on the type of termination that occurred. Where the parties are in dispute in regard to the basis of the termination and therefore the costs that's payable to the contractor and or to the employer, they must follow the dispute resolution mechanisms or go to court to resolve the final payment. If the contract does not provide for a post-termination process, the employer should nevertheless pay to the contractor the amounts which it deems to be reasonably due to the contractor. And again, any dispute in this regard will be referred either to ADR or to the court. All the securities must be returned to the contractor upon termination, subject thereto that the employer may use some of the those securities to cover its damages where the termination resulted from a contractor breach. And it can also use those securities to remedy defects if the termination comes because of a contractor refusing or failing to remedy defects. And typically, the performance bonds would be could be used, as we said, for the wider purpose of any breach by the contractor. And sometimes it's very specifically worded to say upon termination, an employer can call on those bonds. All right. Then moving over to time is of the essence. What this term means is that the stated time for completion of an obligation in terms of a contract becomes or is a condition of the contract. So when it's said that time is of the essence in a contract, it is meant that failure to perform by that time that's specified must be regarded a breach of such magnitude as to justify the other party in cancelling the contract. So time can be of the essence either through an express provision in the contract, and setting a completion date in these construction contracts is not sufficient to make time of the essence. In fact, typically we don't want or have time of the essence in construction contracts because we've got mechanisms through which we can change the stipulated completion date. It can also, time can become of the essence through an implied term in the contract. So it's where it can be implied from the terms of the contract that a breach of a time obligation will be treated as a condition and thereby allowing the innocent party to rescind or terminate the contract and claim damages. The last one is conduct. So time can be made of the essence by notice when the contract does not fix a time for performance, although limited to failure to perform an essential term or vital or important term going to the root of the contract. So for example, where one party has caused a delay, the other party can then give notice to that party and say, you are now required to complete by another day, another certain date, and that would then make time of the essence. All right, a clause fixing a time for performance and stating that that time is of the essence is in its nature a forfeiture clause. And as we said, these are not typical to construction contracts because they are generally mechanisms to allow for adjustments to the date. However, so it won't be in the interest of construction contract parties to have time of the essence because they then would lose all of the other remedies that we've spoken about. We know time for performance is fixed, but time is of the essence. The debtor is not in mora, and the creditor cannot cancel for non-performance unless a proper demand for performance has been made. So where time for performance is fixed, the debtor's failure to perform by that time is automatically a breach. And the next step is then to decide whether time is of the essence of the contract. Because if it is the breach of sufficient magnitude to justify the creditor cancelling, i.e. if time is of the essence, then the remedy of cancellation kicks in. Okay, so this inquiry involves determining from the nature of the contract and the surrounding circumstances that the time was of the essence. So a court will firstly look at whether there was a requirement for something to be completed by a certain time. It would then look whether the breach of that specified term or time obligation falls within this definition of time being of the essence. And then it would determine through surrounding facts and circumstances whether or not a termination was valid for that ground. So the question is in fact and not in law. The effect where time is of the essence and that clause is breached is that the contract is terminated and damages is claimed. The converse of this idea of time being of the essence is that time is at large. And this is something that we do find in construction contracts from time to time. If time is at large, it means that there's no date for completion, or it means that the date for completion has become invalid. For instance, there's either no mechanism for an extension of that date, or the mechanism for extension of that date itself has fallen away or has become invalid or has failed. Then the contractor is no longer bound by the obligation to complete the works by a certain date. So the client would then not be able to claim liquidated damages, and the contractor would only have to complete the work within reasonable time. So just to note here, when you are drafting a contract and you're drafting extension clauses and mechanisms through which a contractor can apply to have its completion date extended and determined in a fair and reasonable manner, it's very important to make sure that that mechanism practically works and that it's lawful. Otherwise, you might sit with a situation where time has become at large. Okay, so if time is at large, the contractor will only be required to complete the work within a reasonable time, failing which damages can then be claimed by the employer at common law. Okay. Then damages can be claimed for any breach of contract, subject to the provisions either of the contract itself or of the common law. So provisions in contract govern specific entitlements outside of the common law. For example, standard form contracts have termination cost claims, which is usually more limited than a general damages claim. Or it can be claimed in common law as either general or special damages. In the matter of ARF 2016 Tygerberg, trading as Aspen Promotions versus Pick n Pay retailers, the court said, in principle, a party aggrieved by a breach of contract is entitled to claim as damages his bargain in the sense of what he would have gained if the contract had been properly performed, as well as his loss in the sense of the expenditure he would not have incurred if the contract had not been entered into. So we have this distinction between general damages and special damages. The aim of damages is obviously to compensate the true loss suffered by an innocent party and place them in the same position as far as it is possible, using only money as if the contract had been performed. These would include payment of work done, costs wasted under, for instance, lease agreements, equipment plant hire agreements, and labor agreements, etc. Overhead costs, unavoidable costs to the extent they flow directly from the breach. So direct or general damages are those damages that flow directly and natural from a party's breach. They do not have to be specifically pleaded, while special damages do have to be specifically pleaded. In MV Snow Crystal Transnet Limited, trading as National Ports Authority versus the owner of MV Snow Crystal, the inquiry was summarized as follows. One must inquire whether, having regard to the subject matter and the terms of the contract, the harm that was suffered can be said to have been reasonably foreseeable as a realistic possibility. So that is inquiring into whether it's a general damage or special damage, because special damages are then those caused by a breach of contract but are deemed as being too remote to be recoverable unless the parties actually or presumptively contemplated at the time of contract conclusion that such damages would probably result from a certain breach. So in South African law, indirect and consequential damages are considered special damages, and we don't distinguish between the two. A party would only be entitled to special damages if it can prove two things. Firstly, there are special circumstances which make it reasonable to presume that the contract parties contemplated the damage as a probable result of the breach of contract. And secondly, the contracting parties entered into the contract with these special circumstances in mind, i.e. the parties had agreed expressly or tacitly that there would be liability for such damages. Loss of income is regarded as a special damage and can therefore only be proven or claimed if the aforementioned two things are proven. So talking about what damages are typically claimed, and I'm just going to run through a few examples. It's not exclusive. Physical damage, such as defective work, repair or replacement, wasted costs such as standing time expenses or double work, P's and G's, preliminary and generals, being costs not directly related to the building costs, but nevertheless necessary, such as overheads and site establishment, financial or out-of-pocket expenses. So those are the expenses you wouldn't have incurred if the contract hadn't taken place. Economic loss, which is more relevant to where there's a negligent breach, and in which case wrongfulness must be established. So if public policy considerations demand that in the circumstances the plaintiff has to be compensated for the loss caused by the negligent act or omission of the defendant, then pure economic loss could be claimed. Consequential losses such as loss of profits, loss of business, loss of revenue, third-party liability or third-party claims, and then subcontractor costs, subcontractor losses for which the contractor is liable. In all of these, a cause and effect must be shown to be successful with a damages claim because damage will not be presumed. So firstly, one has to establish a factual causation using the but-for test. In other words, would the damages have occurred but for the breach? Factually, the guilty party's breach must have caused the damage. And then you have to establish legal causation. Is there a legal liability for the damage sought on the part of the wrongdoer? Here, limitations of liability and difference between general and special damages become relevant. When do we claim when do we calculate our damages? It should be calculated as at the time they were due, which is often the time when the breach occurred. If the breach is in the case of non-performance or positive malperformance, if that occurs at the time the performance was due, then the time at which the damages should be calculated is the time of the breach. In the case of a repudiation, the time when performance was due is used as the time to calculate damages. And in the case of repudiation where there was no time for performance, the time when the plaintiff quantifies the loss by either resale or repurchase is used, provided that there was no delay. All right, contractor claims. If the claim comes prior to work even commencing, the contractor can typically claim its out-of-pocket expenses and expenses incurred in expectation of completing the contract. It could also possibly claim a loss of profit subject to contractual limitations. Where the work has been partly carried out, it is said that a contractor's obligation to complete the work is generally indivisible. So absent a specific contract clause entitling the contract to part payment or work being certified for payment in an interim payment certificate, it would generally have to claim partly completed work on the basis of unjustified enrichment. The contractor does not have a common law right to interim payments for work partly carried out. And the contractor can nevertheless claim all damages that it can prove. In some instances, the contractor would be able to claim a reduced contract price even though he has not completed the works. This was previously referred to as quantum merit, but the courts have moved slightly away from that term. To succeed in a claim for a reduced contract price, the contractor needs to prove the following: that the employer is utilizing the incomplete performance. The contractor must show that the employer has benefited from the work or has taken steps to enrich himself at the expense of the contractor. That the circumstances exist making it equitable for the court to exercise its discretion in the contractor's favor. There must be a bona fide belief on the part of the contractor that he has completed the work. And then also you must show or prove what the reduced price should be. How much will it cost to put the contractor's performance in order so that it can be determined by how much the contract price should be reduced. In the matter of BK Tooling versus Scope Engineering, it was provided. It was said that provided the employer has benefited and provided the claim is assessed in a manner which does not leave the employer worse off than had the performance been completed, this claim can be successful. Okay, in terms of employer claims, the employer is entitled, as part of its damages, to claim the costs of completing the work, less the balance of the contract price, which would have been paid to the guilty party to complete the work. So it's only entitled to claim additional expenses of completing the work and not the full contract price, because of course it is getting a benefit from work done. And it can obviously claim for defective work. So where the work was left inapt or half-baked, the cost of remedying and replacing can also be claimed. When we're talking about damages, we shouldn't lose sight of prospective damages, and these should be claimed at the same time when you claim your accrued damages. As the law currently stands, it's doubtful whether prospective damages have been claimed in certain instances without accrued damages being claimed. So the accepted position is that you claim your accrued damages and you then also allow for prospective damages within that claim. So the limitation of liability clauses could exclude consequential losses. It could limit your exposure, such as an overall limitation on liability for any breach at a fixed sum or a percentage value of the price. There could be a limitation through insurance. In other words, any payout under insurance has to be deducted from damages claims. You could include indemnities. Concurrency, which we'll chat about later, automatically excludes certain losses by law. And that's on the principle that one cannot benefit from your own wrongdoing. And you can then also exclude special damages or only include specific special damages such as a loss of profit. And then I just quickly want to run through global claims, which is, well, let's first say the normal approach to making a claim for damages is that the claimant sets out each event that it claims is the responsibility of the defendant, the existence of loss and expense suffered by the claimant, and then the causal link between the two. If the causal link cannot be established between the event and the loss complained of, then the claim will necessarily fail. A global claim is a claim where that causal connection between the matters complained of and their consequences, whether in terms of time or money, are not fully spelled out. Based on the judgment of Improfed versus National Transport Commission, global claims are not yet accepted in South Africa, although it is accepted in many other jurisdictions. So in that matter, the claim was dismissed for being a general one for delay and disruption caused by diverse circumstances, some of which are unrelated to the conduct or the responsibility of the respondent. For example, inclement weather and the appellant's own mistakes and misfortunes. Evidence was laid on all the disparate causes for the delay, but no real and certainly no successful attempt was made to assess how much of the loss of productivity could be attributed to each case. When the matter went on to appeal, it was agreed that neither in the pleadings nor in the evidence did the appellant even begin to isolate, estimate, or quantify the effect of each separate cause contributing to the overall delay in completing the contract. And the appellant, in its evidence, failed to establish that the non-productive period in respect of each unit was due to a delay or disruption for which the respondent was responsible. In another matter, Group 5 versus Minister of Public Works and Land Affairs, the contractor attempted to argue that none of the clauses as contained in the contract precluded it from making a global claim for the overall financial consequences of delay. However, the employer argued that the provisions of various clauses within the contract are not interchangeable and that they deal with different situations and prescribe different procedures. It is hence important for a contractor to stipulate on which clause he is relying, and there's no room for an overall global approach. And the judge agreed with the employer. So it is still in South Africa necessary for a cause and effect to be shown.
Okay, I'm going to continue with the topic of penalties. So penalties is one of the provisions in a contract that's always heavily negotiated. So at the time of contracting, it's not uncommon for parties to include a term in the contract for a fixed sum of money that is due in the event of a breach by the contractor to achieve the time for completion. So payment of this fixed sum of money is also referred to then obviously as delay liquidated damages or just liquidated damages, depending on what the sum of money relates to. The purpose of that penalty provision is a deterrent to the contractor for a breach. And it's important for the employer to, when that provision is negotiated, to consider and to strike a balance between incentivizing proper performance on the part of the contractor versus just penalizing the contractor for its failures. Because ultimately you still want to motivate the contractor to achieve the time for completion. So as I've just mentioned, examples of liquidated damages or penalties can be in relation to delays or where the contractor is obliged to achieve certain performance levels. It can also be liable for performance liquidated damages. The defenses to penalties is usually when a penalty is out of proportion, considering the prejudice that the creditor or the employer is suffering. And that is based on the provisions of the Conventional Penalties Act, which determines that no entitlement to claim general damages in lieu of penalties will be allowed unless the contract provides otherwise. The court may reduce the penalty amount to such an extent that it considers it equitable in the circumstances, and if it considers that the penalty is to be out of proportion to the prejudice suffered by the creditor or the employer. So we also generally see that parties negotiate a cap on liquidated damages. That is also a mechanism to incentivize the contractor that there is some form of a limit to that amount of damages. The implementation of liquidated damages is by way of a determination. So it's not just imposed or it's not automatic. The employer still needs to follow the contract process to claim the penalties, and that penalties will then be determined, or the claim will be determined by the employer's agent, and it will be certified. As we've looked at the payment certificate or the form of the payment certificate a moment ago, that amount will then be set off against an amount that's due to the contractor for performance of the work. We are going to discuss the set-off principles in a moment. So we've briefly referred there to the effects of insolvency, and we'll also then discuss the set-off principles. I'm not going to discuss it now. And then we can quickly just go through any other remedies that are available to the employer in relation to the breaches. So specific performance, the employer can interdict against the breach of the contract. The employer has a right to step in certain circumstances of breach. The employer can also impose a reduction on the scope of work or reject the works. I will then move on to step-in rights. Okay, so what is a step-in right? A step-in right is the right of a third party, such as the employer, to step into a contract, such like a subcontract, and take over the rights and obligations of another party in specific circumstances. So if I can just give an example, so it's generally in the interest of the employer that a subcontract would be successful. So if the employer is under the impression or is advised that there's a breach by the contractor in terms of the subcontract, there might be a right for the employer to step into that subcontract and ensure that proper performance of the contractor's obligations occur. So a step-in right is usually in the form of a collateral warranty. So the example is a collateral warranty from a subcontractor is in favor of an employer. It may also include the step-in right primarily to give effect to the employer a contractual right to step into the subcontract if the main contractor becomes insolvent, for example. So a step-in rights prior to termination. The examples where that would usually occur is in relation to remedying of defects, where there's slow progress or other breaches. The employer then generally has the discretion to step in and perform the works of the contractor itself by way of the appointment of a third party and then recover the costs from the contractor. Other examples where the employer may exercise its step-in rights is where there's a failure to provide any services or loss of a license or authorization by the contractor, where there's a repeated breach of a single critical obligation by the contractor, or where the contractor's financial security is exhausted, or the liability cap is reached. Typically, step-in rights will require notice periods before the third party can exercise that step-in right. So that, for example, if the contractor or the consultants are not paid by the client, they must give notice to the funder before terminating the contract, allowing the funder time to decide whether to step in to the employer or the client's position. Such agreements may include provisions for the funder to pay the costs during this notice period, whether the step-in right is exercised or not. So step-in rights, just with regards to subcontractors, as I've mentioned before, the employer also has the right to pay subcontractors directly where the contractor fails to make payment. That is also a form of a step-in right. Okay, then we are moving on to the effects of insolvency. The reason why we're discussing the effects of insolvency is that in South Africa and in the current economic environment, it's not uncommon for small contractors or subcontractors to go bust. So we find that clients often are in a situation where they have to deal with insolvency. So what if either party then into a construction contract goes insolvent? As you know, the Insolvency Act regulates insolvent estates. So the effect of insolvency on a high level is that the liquidator can elect whether to uphold or repudiate the construction contract. If the contract is upheld, it needs to enforce all the terms and provisions of the contract, and it cannot just cherry pick which provisions it wants to enforce. So it steps into the shoes of the contractor. So in this regard, as you know, contract clauses generally provide a right of immediate termination upon the occurrence of an insolvency event. And the question that arises is what happens with a claim by the employer, such as termination cost claims, post liquidation. So we'll briefly, in light of this question, look at the common law requirements for set-off. Because, as you know, in terms of construction contracts, there's always, or generally, not always, generally a set-off mechanism that applies between claims by the contractor and claims by the employer, which is certified in the payment certificates. So the common law requirements for set-off are that reciprocal debts must exist between the same parties. Both debts must be due and payable and therefore enforceable. and the debts must be liquidated. In other words, capable of speedy and easy proof. So, however, the common law set-off cannot take place post-liquidation. And this is very important because it would disturb the concursus creditorium. The law seeks to enforce that all creditors are treated equally once liquidation proceedings have commenced. So if set-off was allowed, the creditors with a counterclaim would benefit at the expense of others. So these creditors would recover in full, or to a greater extent than the other creditors, what is owed to them by way of the set-off, whilst the other creditors would only receive their pro rata dividend. So in terms of common law, the employer would not be able to allege that it has a counterclaim and that amount of the counterclaim must be set off against what is due to the liquidated contractor. Instead, the employer must pay the liquidators the full debt owed to the contractor and then lodge a claim for what is owed to them by the liquidated company. So in due course, the solvent counterparty will receive a liquidation dividend if there are funds available for distribution to the concurrent creditors. However, as I've said, if the construction contract provides for a set-off mechanism, the position would be different where the liquidators step into the shoes of the liquidated contractor, because they would remain bound by the rights and obligations contained in the contract unless they elect to repudiate those terms. So in the circumstances where a liquidator seeks to enforce a construction contract that expressly provides for a set-off between the parties, the liquidator elects to abide by the terms of the contract. That would include the provisions that allow for set-off of claims. So if the contract provides that an amount only becomes due to the contractor after certain counterclaims by the employer have been taken into account, in other words, deducted or set off, the liquidators will be obliged to abide by those contractual terms. And they cannot seek to enforce the contract whilst ignoring some of the inconvenient terms. Okay, so that's it on the effects of insolvency. We'll move on to completion. Okay, I would like to show these completion regimes that you generally find in construction contracts. So you have the commencement date, then it's followed by a takeover or sectional takeover certificate. And then you also find the part takeover regime, which we'll discuss in a moment. Generally, after the takeover or sectional takeover certificate, the defects notification period will run, following which the performance certificate is issued, and that then constitutes completion of the project. Another regime is under some of the standard contracts, it's the commencement date, followed by practical completion or deemed practical completion, sectional completion. Following which there's an opportunity to remedy defects and complete some of the outstanding works, after which a works completion certificate will be issued. And then the defects liability period will run, during which all the defects that's listed in the works completion list must be completed. And then if that is complied with, the final completion certificate will be issued. In some contracts, it governs for a latent defects liability period. That's generally around about 5 years, but that also depends, the latent defect liability period and the defects liability period, for that matter, will always be dependent upon the scope of work and the nature of the project. Okay, so now we'll just look at the regimes. Sectional completion. So if the works are completed in sections or parts, we've briefly discussed this yesterday as well, the agent may, at its discretion of the employer, issue a certificate to confirm that sectional completion is achieved. Then practical completion or takeover, that is generally when under the contract considers to be achieved when the works is fit for the intended purposes, save for minor defects or outstanding works. Completion will then be issued it will be achieved by way of a certificate that's issued by the employer's agent, and that is deemed as the acceptance of the works. All defects will at that stage be remedied, save for latent defects. And like I said, in some instances, the latent defects notification period will commence if it's legislated for in the contract. Now, we will just briefly consider the deemed completion regime. So construction contracts generally provide for deemed completion regimes in circumstances where the employer starts to use the works or parts thereof, because in this event, the contractor shall cease to be liable for the care of such parts of the works from the date that the employer starts to use the works or the parts thereof. And it's mainly for the reason that the contractor is no longer in control of that portion of the works, and it cannot be expected of a contractor to carry that risk. Okay, and then we'll look at the period for remedying defects. As I mentioned, you generally find a defects notification period, or and in some instances, latent defects notification period. Lisa Marie already discussed what constitute latent and patent defects, so I'm not going to discuss that again. So if the works cannot be used for the purposes for which they are intended by reason of a defect or damage, the employer would generally be entitled to claim extension of the defects notification period. And then I think we've also mentioned that earlier on, is that if there's no completion date or it cannot be ascertained from the contract, time would be at large. Okay, so the next topic for discussion is delay, disruption, and acceleration. So the definition of delay is, in the case of delay, we are talking about the contractor being delayed in proceeding with the works. Delay involves an analysis of the time on the critical path, meaning which is necessary to support an extension of time claimed by the contractor. So it's critical when there's a delay ultimately to the time for completion. A typical monetary claims dependent on the analysis of time are a relief from liquidated damages, compensation for time-related costs, i.e. additional on-site expenses, increased labor and material costs, unproductive labor, additional costs for financing and insurance, loss of profit, and site overheads. And then the next category is compensation for acceleration steps in an attempt to mitigate the delay caused by the employer. So those are the typical monetary claims you would find. In an analysis of delay, it includes an assessment of the cause of the delay and the effect of the delay. It also includes an analysis of the critical path and whether the delay event, actually has an impact on the ultimate completion of the project. Concurrent delay, if there's a period of the project that overruns, which is caused by two or more effective causes of delay, which are approximately equal in causative potency. So the three types of concurrent delays that you can find is if there are two or more effective causes of delay, one or more attributable to the contractor and one or more to the employer. Or you would find where there are two or more effective causes of delay where all the delays may be attributable to the contractor, or two or more effective delays, causes of delay where all the causes of delay may be attributable to the employer. So it should go without saying that the contractor will only be entitled to an extension of time for delays attributable to the employer. As you already know, the relief that one would be entitled to in respect of delay is, well, if it's successful in the claim for delay, is the time and in some instances, the money or the cost associated with the delay. we're going to look at the delay analysis approach. So the two different approaches is one is a static approach, a dynamic approach. The static approach is based on theoretical impact of delay based on the impact of the delaying event on the planned program of work. It's very simplistic. Then the dynamic approach focuses on how the works have progressed based on an updated program and how the activities were delayed to ascertain whether delay events actually caused the delay. So the effect is calculated in relation to its impact on the as-built program and therefore takes account of the contractor's culpable delays or additional float that may have been created on the program. So we also going to look at the Society of Construction Laws Delay and Disruption Protocol, which includes guidance on delay, disruption, and acceleration concepts. The object of this protocol is to provide useful guidance on some of the common delay and disruption issues that arise on construction projects, where one party wishes to recover from the other an extension of time and or compensation for additional time spent and the resources used to complete the project. The purpose of the protocol is to provide a means by which the parties can resolve these matters and avoid unnecessary disputes. The focus of the protocol, therefore, is the provision of practical and principled guidance on proportionate measures for dealing with delay and disruption issues that can be applied in relation to all projects, regardless of the complexity or scale, to avoid disputes and where disputes are unavoidable, to limit the cost of those disputes. Okay, then we're also going to consider disruption and how that differs from delay. So in referring to disruption, the protocol is concerned with disturbance, hindrance, or the interruption to a contractor's normal working methods, not necessarily the time for completion. It can result in a delay to the time for completion, but it results in lower productivity or efficiency in the execution of a particular work activity. So if the contractor is prevented from following what was its reasonable plan at the time of entering the contract, carrying out the works, or a part thereof, the likelihood is that its resources will accomplish a lower productivity rate than what it initially planned. So overall, those work activities will cost more to complete, and the contractor's profitability will be lower than anticipated. Work that is carried out with a lower than reasonable anticipated productivity rate will lead to activity delay and the need for acceleration, or a combination of both, and therefore in each case loss and expense. So disruption is concerned with analysis of the productivity of the contractor's work activities, irrespective of whether those activities are on the critical path to completion of the works. It can also include where there's a change in the sequence or method of the contractor's work activities. The next concept that we're going to look at is acceleration. Acceleration, what is that? It is the process of speeding up the work of a contractor so that the work can achieve completion on or before the date required under the contract. So generally acceleration, it is the employer that requires the acceleration of construction work. An employer might require that a building is handed over earlier than it is set out in the contract, or where the contractor has been allowed an extension of time, the employer may require completion earlier than the revised completion date. This is referred to as directed acceleration because it comes from an instruction from the employer. However, where the contractor accelerates work voluntarily, for example, they wish to move on to another project or to mitigate inefficiencies and delays that may have been incurred, or to prevent liquidated damages to be incurred, this acceleration will be performed at its own risk, and it will not be able to claim additional costs from the client or the employer. Where the contract incurs additional costs as a result of acceleration by the employer's instruction, it can result in a claim against the employer. Then the techniques that the contractor would generally apply for purposes of acceleration is working overtime, adding new shifts, providing additional labor, additional supervision, providing additional resources such as plant and equipment, resequencing of the activities, also known as a project crashing or fast tracking. It can adopt alternative construction methods such as off-site manufacturing, changing the design or the specifications, reducing the scope of the work, and early procurement of key items. Then, for purposes of for demonstrating acceleration measures, the program and documents again is the only way to demonstrate the actual acceleration. So that's why the record keeping is essential. The claim process needs to be followed to implement your entitlement to claim costs for acceleration. So the claim document must explain the legal basis for your entitlement, whether that is under the contract or a common law. This is because delay, disruption, and acceleration are not causes of action in their own right. In addition, the claim document must explain the cause of the delay, the disruption, or acceleration, and the remedies claimed. Claims by contractors for delays, disruptions related to loss and expense must be proved on a balance of probabilities that firstly, the events occurred entitled it to loss and expense claim. Those events caused a delay and disruption, and such delay or disruption caused it to incur the loss and expense. In relation to these analysis and assessments of delay, disruption, and acceleration, employers or contractors will usually rely on experts to assist in formulating those claims.
Okay. So an extension of time clause enables the employer to set a new completion date in the event that the contractor is delayed by circumstances for which the contractor is not liable or for which he does not bear the risk. The contractual rights are maintained, albeit in accordance with a new date, thereby preserving the employer's right to impose penalties or claim damages in the event that the contractor fails to complete by this new completion date. And the amount of time available to the contractor to complete the work before the penalties or damages might be imposed is preserved so that it's not prejudiced on account of a delay for which it is not liable. The extension of time and additional compensation clauses that we find in a contract specifies the events for which a contractor would be entitled to an extension of time. Limited. So there's no automatic right for a time extension under the standard form contracts. We have seen very, very few contracts which seem to be drafted in the sense that there's an automatic right, but for the most part, you will see that there are requirements before that entitlement is established. Additional compensation would follow, and some events might only have the one or the other as a remedy. The requirements for an EOT is that a contractor must prove that it was delayed on the critical path of the program that's current at the time of the delay, and the delay was one for which the contractor was not liable. And we'll deal with the critical path separately in a little bit later on. Just for purposes of an EOT, know that the delay must be on the critical path. A contract which has no extension of time provision actually puts the employer at risk, because in those circumstances, a delay for which the contractor is not liable renders the completion date unenforceable, The penalties which are linked to the completion date will fall away. And once the original completion date has passed, the employer will have to place the contractor in mora, giving the contractor reasonable time to complete before it will be a breach of the contractor and a commensurate entitlement on the part of the employer to claim damages for non-timeous performance. All right, so let's just quickly run through the difference between a critical path and a longest path, and you'll hear more about these two things a little bit later. So a critical path is, and this relates to a path on the program, on the schedule, the work schedule. So a critical path is a path through the project which has activities that's considered critical for completion. And it also shows the completion of activities that are critical for a next activity to start. So just in very simple terms, when you're building a house, you have to do the foundations before you can do the walls, and you have to do the walls before you can do the windows and the roof, etc. So a critical path means your first path would be through the foundations, your second path would be through the walls, and your third critical path would be through the roof, just as a very basic example. And these activities follow on each other. The one must be completed before another one can start. So it can't be started out of sequence. A longest path is the path through a project from start to finish, where the total duration is longer than any other path. So that is typically just a group of activities or one activity that takes the longest in a project or that has the longest path. So a longest path is likely to be part of the critical path, but not all critical paths will be a longest path, for instance. Then dealing with additional costs and what that means. In common law, an extension of time has nothing to do with monetary compensation for delays. Thus, in the absence of a provision in the contract linking monetary compensation to the granting of an extension of time, the contractor will have to recover its monetary loss in the same way that it does in the event of a disruption. So where there is a contractual provision, the contractor's entitlement will be governed by the terms of that provision. And this may include conditions precedent, such as the giving of a notice, which sets periods and or the degree of particularity required to adjudicate the claim. So there's two ways in which a contractor can recover loss or damage that is associated with an extension of time. It's either through the provision of the contract, which is very specific to the compensation and the event for which that compensation would apply, and in terms of a common law as a claim for damages arising from a breach on the part of the employer. The types of claim, or as we call them, heads of claim, that's associated typically with additional compensation. They are also set out in the various standard form contracts, and some of them might be subject to limitations of liability. So certain standard form contracts do link compensation to extensions of time, and this is usually achieved by stipulating that certain time-related P's and G costs would be payable in certain instances. Under the common law, the usual requirements for breach will have to be satisfied, so the employer must be in culpable delay, and the damage must flow naturally from that breach. There are various methodologies that are used by quantum experts to ascertain what the true quantum can be of an additional cost claim. And the experts don't always agree on which methodology to use. So this is quite a complex issue that we're not going to get into today. But basically, the methodology that you use is very much reliant on the types of documents that you've got and information that you've got. So where the experts from both parties don't agree which methodology is most relevant, the adjudicator, the arbitrator, or the court will decide which report, which methodology is more suitable in their opinion. Supporting documents have to be provided, as actual cost must be proven in most circumstances. So it's very, very important, especially if you're a project manager, to keep accurate records of all the costs on a project and that they are properly linked to each activity. This is obviously a very time-intensive and strenuous task, but at the end of the day, if you don't have the supporting documents, your quantum is going to probably be a lot less than what you're really entitled to. Looking at actual cost versus forecast cost methodologies. So actual costs are, as the phrase indicates, the actual costs that's incurred by a party, and it's proven by the supporting documents such as the payroll records, financial documents, site records, rental agreements, invoices, and the like. This is the preferred method of calculating additional compensation. And even if a contract specifically allows for forecast costs, this method is preferred by almost every adjudicator and arbitrator where actual cost can be determined. So forecast costs are those which are not yet known at the time that you are making your claim, but is estimated to be incurred. And that can be costs of remedying defects, for instance, where you haven't yet received a quote or an invoice for that work. So a party furnishes the estimate of costs based on item rates that already exist in the contract bill of quantities or according to the schedule of values. It can come from estimates received from suppliers, and it can also be from other market-related data. So depending on the provisions of the contract, an interim cost calculation can be performed using the forecast cost method. So this is typically where you're making a claim as and when they arise. And then when the actual cost amount can be calculated at a later stage, the actual cost method is then used to finally determine a claim. And this is the common approach that's taken in construction claims. Okay, so we are then going to deal with concurrent delay and the prevention principle. So a period of project overrun, which is caused by 2 or more effective causes of delay, which are approximately equal in causative potency, is a concurrent delay. So you get a true concurrent delay, and then you get another type of concurrent delay that we'll discuss. So a true concurrent delay is actually the occurrence of 2 or more delay events at the same time, one being an employer risk event, the other being a contractor risk event, and the effects of which are felt at the same time or even overlapping. So for a concurrent delay to exist, each of the employer risk event and the contractor risk event must be an effective cause of delay to completion, i.e. it must be a part. The second type of concurrent delay that we see is where there's 2 or more effective causes of delay, where all the delays may be attributable to one party. So the contractor is suffering a delay, but it's because of 2 of its own risk events or more. Okay, so where there is concurrency, the following principles have to be applied. So to evaluate true concurrency, it's vital to establish if the event would have had concurrent effect to the progress of the works. And then if that's established, you have to arrive at a suitable method to ascertain the contribution of this event to the critical delays incurred within the period analyzed. So South Africa has adopted the Malmaison approach, which comes from the decision in Henry Boot Construction versus Malmaison Hotel. It's a UK case, and it's a leading case on this issue. So under this approach, where there are 2 concurrent causes of delay, one an employer risk event and the other not, the contractor is entitled to an extension of time for the period of delay caused by the employer risk event, notwithstanding the concurrent effect of the other event. So as an example, a builder is unable to work for a week because he has a shortage of labor. That's his own risk event. And at the same time, there is inclement weather. which is an employer risk event. The project managers should in this instance grant an extension of time for the inclement weather if he believes that that's fair to do so, and he cannot rely solely on the contractor's culpable delay, being the shortage of labor, to refuse an extension of time. So where a contractor delay to completion occurs concurrently with an employer delay to completion, the contractor's concurrent delay should not reduce any EOT due, and the employer should not be able to assist on compliance from the contractor when the ability to do so is compromised by the employer's own actions or omissions. If the contractor incurs additional cost due to concurrent delays, it should only recover compensation if it's able to separate the additional costs caused by the employer delay from those caused by the contractor delay. If it would have incurred the additional costs in any event as a result of a contractor delay, then the contractor will not be entitled to recover those additional costs. So in terms of concurrency, where there's more than one contractor risk event, so that's not a true concurrency that causes the delay, the contractor can only claim for one event for a particular period on the critical path. So one method of analyzing this is using the longest path analysis, where the path of each delay event is analyzed to find which event had the longest path. Insofar as that is on the critical path, an extension of time will be granted if that is an employer risk event. So contractors often claim for all delay events, irrespective of concurrency, so as to cover all of their bases. So if it's found that one of those events do not entitle the contractor to an extension of time, they still have the other that ran concurrently to use for a basis of an EOT. Okay, and then the prevention principle is a long-established principle under the English law that prohibits a party to a contract from enforcing an obligation against its counterparty in circumstances where the party seeking to enforce has prevented the counterparty from performing. Now, that is not a principle that we follow in South Africa. Under South African law, we have the supervening impossibility principle, which we talked about yesterday. And you can look at the matter of Adyart Abu Dhabi versus Marine Services. Okay, then the requirements. So you can't get an extension of time just because your obligations are suddenly more onerous, difficult, or costly. There must be an absolute factual impossibility to not be able to do the work. It must be objectively impossible. All right. Then moving on quickly to time bar, which is a very important part of what you'll see in construction contracts. So this requires notice to be given or something to be done within a certain specified time, failing which the entitlement to claim will be extinguished. So such clauses may be viewed as being very draconian, and as a consequence, the courts do interpret them strictly. This means that in the event of there being an interpretation which will have less harsh consequences for the contractor, the court will prefer such interpretation. Adjudicators and arbitrators are also cautious to accept a time bar condition or clause unconditionally. They tend to look at the surrounding circumstances and the facts, for example, estoppel on the basis of an employer's conduct, the true knowledge by the employer of the event or the issue that is subjected to the time bar, the impact of lateness of a notice, etc. So a time bar can apply to claims by the contractor. So those are mostly found to apply to notification of a claim, and sometimes it extends to giving particulars of the claim with supporting documents. Seldomly, it applies to claims by an employer, objecting to a determination by a project manager could have a time bar, thereby having an effect on your entitlement to refer it as a dispute to ADR. Notifying a dispute and sometimes even referring a dispute to ADR might have time bar attached to it. And then also when you're objecting to an award under adjudication. So a notice of dissatisfaction typically has to be given within a certain time, failing which the adjudication award becomes final and binding. So just quickly looking at examples under FIDIC, and I'm using the FIDIC 2017 version, notice of claim. I'm just going to read to you what these time barring provisions typically look like. If the claiming party fails to give a notice of claim within the period of 28 days, the claiming party shall not be entitled to any additional payment. The contract price shall not be reduced. The time for completion of the DNP shall not be extended, and the other party shall be discharged from any liability in connection with the event or circumstance giving rise to the claim. So this differs slightly from time bar that we find in other situations that's not relevant to a claim. For instance, under the NEC 3, 2013 version, if you look at the dispute resolution clause W1, there you'll see an adjudication table, and it says when may it be referred to an adjudicator, a dispute, and it says between 2 and 4 weeks after the contractor's notification of the dispute, the notification itself being made not more than 4 weeks. And it then goes on and says if a disputed matter is not notified and referred within the time set out in this contract, neither party may subsequently refer it to the adjudicator or the tribunal, being arbitration. Further, it says that the adjudicator, if after the adjudicator notifies his decision, a party is dissatisfied, he may notify the other that he intends to refer it to the tribunal. A party may not refer a dispute to the tribunal unless this notification is given within 4 weeks of notification of the adjudicator. So these are the clauses you need to be very aware of, and you need to consider carefully. All right, so then the last one we're talking about today is ADR, and I'm going to run through it very quickly. So what is alternative dispute resolution? It's a process of settling disputes using negotiation, mediation, arbitration, or other forms that is not litigation through a court process. And it's only possible to use these methods where the parties have specifically agreed to it. There's no common law right to use any of these mechanisms. So the popular mechanisms we find in standard form contracts is generally an adjudication followed by arbitration. We sometimes have amicable settlement. So what is adjudication? That's where the parties refer a dispute to an independent third party. And the purpose of an adjudication is that it should be used as a swift and a cost-effective resolution of disputes between the parties while the project is still ongoing, so as and when they arise. It ought to be resolved on paper only and not as an arbitration. So it should be kind of a quick and dirty. The answer doesn't always have to be completely correct. All of the information doesn't always have to be given. It's just an interim measure that can be used by the parties to ensure that the project is not hindered by disputes between the parties. So you have a standing adjudication, you've got an ad hoc adjudication. Standing adjudication is where either one adjudicator or a panel of 3 is agreed up front when the contract is concluded. And these people are then on a retainer basis employed by the parties to deal with every single dispute that happens. And often the benefit of that is they start to understand your project, they know what the history is of claims, of disputes between the parties, and they know the documents, and they can quickly make a decision. An ad hoc adjudication is where there's a single adjudicator that's appointed every time as and when a dispute arises. And then we've got in 2017 FIDIC, the Dispute Avoidance Board that was introduced, and some of the other contracts have followed suit. But this is really, it's a standing adjudication board that's not just used for adjudications, they're also used to try and resolve issues between the parties before they become full-blown disputes. This is very much like a mediatory role, helping the parties to reach compromise or a commercial settlement to avoid disputes. Okay, so this is an interim measure. we then have arbitration, which is a final measure. And this is very much like a court process, except a lot more flexible and probably a lot quicker and a little bit less onerous. So again, the parties have to agree to resolve the dispute through arbitration. It cannot be referred unilaterally. Where arbitration is used, the Arbitration Act will apply. And the process of arbitration can include anything. Well, usually it does have written statements of case. It can then also include witness statements. It typically will include expert reports, heads of argument, and it will have a hearing where there will be examination and cross-examination. So it's very much more comprehensive than adjudications, but both adjudications and arbitrations are supposed to be inquisitorial. Okay, then other mechanisms, amicable settlement, that's really just where senior representatives of each party meet and they try to reach a commercial settlement before the matter can be referred to a next level. So these, in the standard form contracts, these ADR mechanisms are often multi-tiered, and you have one that follow on the other, that follow on the other. You also have mediation that is sometimes available to parties in the contracts, and then you have expert determination, which should be used for very limited issues of law or of some technical issue, or maybe even a quantum issue. But it should be very limited, and you then rely on an expert in a specific field. You rely on their expertise, their knowledge of the market to make a determination, which the parties can then decide up front in the contract whether they want to have this as a final and binding determination, or whether they want to kind of have it as a suggestion. But mostly people or parties where they use expert determination would agree that it's final and binding, and that issue will not be referred to adjudication or arbitration again. Okay, so notice provisions. Almost all of these contracts will have a specific provision or specific provisions to notify that you intend to refer something to an adjudication and thereafter intend to refer it to an arbitration. And we've just discussed that there might be time barring involved there. Awards, an adjudicator or an arbitrator typically has a set period within which the award must be given. And this is usually agreed between the parties and the adjudicator, but it can also derive from the Arbitration Act itself. An adjudicator's decision is binding and enforceable, but it can be overturned in arbitration. Usually there's a term in the contract that says if the parties don't issue specifically a notice of dissatisfaction, then it also does become final. An arbitral award is final and binding between the parties, and both of these types of awards are enforceable in court, and our courts readily enforce adjudication awards, even where there is a notice of intention to refer to arbitration. So even where you've notified that you're dissatisfied with the adjudicator's award, you're going to refer, you have already referred it to arbitration. The court says, I'm enforcing this award until you come back with an arbitration award which says something different. Okay, and then there are grounds for challenging an award. So in adjudication, it's very important to understand the principles of natural justice do not apply. So even where the adjudicator gets it wrong with reference to facts or law, his decision will be binding and enforceable. And this is simply because you have a second tier, which is arbitration. So an adjudicator's award cannot be challenged for that reason. Sometimes it can be challenged for lack of jurisdiction. Well, it can be challenged for lack of jurisdiction, but sometimes that means an award outside of time. So our courts mostly look at the facts surrounding why it was given out of time and what the impact was before deciding whether or not to enforce a late award. But in terms of rendering a decision which manifestly falls outside of the scope for which the adjudicator was appointed, that there you would successfully be able to challenge the award. And you can look at the Framatome case for that. For the arbitration, this is specifically dealt with in Section 33 of the Arbitration Act. And this just says that an award may be set aside where a member of the arbitration tribunal has misconducted themselves in relation to their duties as arbitrator, or where the arbitration tribunal has committed any gross irregularity in the conduct of the arbitration proceedings, or has exceeded its powers, or an award has been improperly obtained. And then lastly, costs. In adjudications, it's not ordinary to seek a cost order from the adjudicator, but the parties can empower the adjudicator to make a cost order. An arbitrator generally already has the power and the discretion to award costs. So when we talk about adjudications and arbitrations and the procedure for these, as I said, it's very flexible and the parties agree which procedure suits them. They can have a bespoke procedure that they agree between them, but typically you would find the parties rely on rules that already exist. So just some of the rules usually used is the JBCC adjudication rules, the CASA's adjudication rules, Arbitration Foundation of South Africa's expedited commercial and construction arbitration rules, ASA's rules for conduct of arbitration. For international arbitrations, we have the ICC rules of arbitration, and we also have the INCITRAL arbitration rules. And that is it for us today. So I know they probably are some questions we haven't yet answered. So please feel free to pop them in the chat box and we'll see how we can answer them. Okay, so one question is, say I am at a point where negotiation and mediation has failed. I need to go to arbitration, which has survived termination. Does prescription apply? And if so, when does it kick in? Yes, so prescription does apply. In terms of the Prescription Act, referral to arbitration, so that statement of case that you send to the arbitrator is the same as a summons, for instance. So it interrupts prescription. So as long as you go to arbitration within the 3-year period as calculated under the Prescription Act, you're fine. Once you have an arbitration award and you go to court and you make that award an order of court, that award only prescribes after 30 years. Okay, so you still then have 30 years to enforce the actual award. Okay, Nicholas, maybe just pop yours in again from yesterday. I might be happy to answer that. While we're waiting for some questions, we would be very thankful if you guys can maybe just send Betty your comments and your suggestions after the session. What worked well for you? What didn't work so well? What did you enjoy? Was the content informative? What would you have liked to see more of? That would be really helpful. All right, so there's a question, when are you getting the manual? So it's really just like a little e-booklet. It'll have a bunch of information and case law in it. We just want to kind of sense check it after these 2 sessions, so it will be sometime next week. Okay, if my standard form contract refers to works completion, does the principal agent issue a works completion certificate before final completion? And I think this comes from the JBCC, the definition works completion. So typically, once a stage of completion of work is done, you should ask for a completion certificate, because that's generally your certificate is the document that shows there's no more dispute as to whether or not work has been done. So if it's work completion, however that must be, however that is defined, if works completion has actually been reached, then the principal agent should issue a works completion certificate. Final completion typically comes only once all defects have been remedied. And that's the stage where things like your retention money gets issued back to you or paid back to you, and payment securities, etc., are released completely. All right, where can we buy the different construction books, for instance, NEC? So you have to buy it at the relevant institute. So you can buy all your FIDIC agreements from FIDIC itself. And as I understand, they do have an option for the hard copies or just a soft electronic copy. The soft copies are obviously a little bit more cheap, or a little bit cheaper. Very important to note is, even if you have the full suite of documents, where you are drafting for the employer or you are the employer, you have to buy a license for every contract that you base every contract that you issue that's based on FIDIC or NEC. So although you don't have to buy new contracts, you do have to buy the license to use the contract specifically every time. And so NEC, you'll be able to buy from NEC directly. Yes, all case references you'll have. So we did go through them very quickly. You'll get those. Thank you, Kenny, for your kind words. We really appreciate that. Okay, then it seems to me that the status of programs contractually matters. NEC is precise in having an accepted program, i.e. binding between the parties as being realistic and practicable. And other programs, FIDIC, GCC, JBCC, the program seems to bind the contractor, not the employer. This seems to hamper using programs in the evaluations of DOT, and thus the program evidence is extra contractual. So Gavin, you are completely correct. Often we have disputes as to what was the accepted program or the agreed program or whatever you want to refer it to, but what was the relevant program against which EOTs should have been determined. So if the parties don't have a specific agreement on that, it opens the door for disputes. But typically you would have some form of an accepted program, which is the aim, that's where your completion date comes from, and it's updated with EOTs. And then you would have a working program, which is a project management tool showing you where you're lacking behind, where you can maybe make up time, etc. Okay, so Nicholas, a subcontractor can't claim from the employer. Subcontractor agreement has a pay when paid clause. Employer doesn't pay the contractor. The contractor does not take steps against the employer. Therefore, the subcontractor's condition for payment is not fulfilled. When is that condition deemed to be fulfilled in terms of fictional fulfillment principle, and when does subcontractor's claim against contractor start to run? So, Nicholas, I don't think that fictional fulfillment will come in here. I don't think that there would be a deemed principle unless specifically provided for in the contract. So what a subcontractor will have to do in this case, if he didn't protect himself through the subcontract terms, is he will have to institute action either through ADR or the court against the contractor, bearing in mind that the contractor could obviously always say, well, I'm busy with X, Y, and Z, and I haven't been paid, so I'm not paying you. So it could become a massive risk for subcontractors, which is why we always draft specific provisions for cooperation and where there's no cooperation at the type of a deemed provision to enable the subcontractor to still enforce its rights. All right, so Maud has asked to explain understanding of general damages under construction law, as it can only be claimed as a non-patrimonial loss and everything else would fall under patrimonial. So I think it's a bit technical. General damages in the sense of construction law is looked at in terms of international law and international accepted principles. It's really just direct damages. So as I said in my definition of general damages in construction law, it is damages that naturally flow from a breach of contract. So those are the damages that parties know at the time of contracting will flow naturally if they breach a certain term. Okay, word an agreement in which there are terms that say if a contractor doesn't pay a subcontractor can claim against the employer be legal, especially if the subcontractor didn't sign the main agreement. So yes, it can be legal, or it is legal. Whether it would be enforceable is very much dependent on the framework. So as we discussed yesterday, sometimes we do incorporate at least parts of the main agreement specifically into a subcontract. And sometimes you do then create direct relationships between the employer and the subcontractor for certain things. So as long as you properly contract for that, there won't be a problem. Okay, if a developer sells units to new owners, and there are latent defects picked up by new owners, who is liable to the new owner, the developer or the contractor? So generally, I think that the owner would go straight to the developer because they have got the contractual nexus with the developer. And the developer would then obviously be able to either join the contractor as a third party to any action or to make its claim from the contractor, ask it to return to site, and then fix the defects. Okay, so would it be advisable then to say that once subcontractors are brought into the project, an addendum be signed by all parties involved, employer, contractor, and subcontractor? I don't think so. I think the main relationship, it shouldn't be a tripartite agreement. It should be a main contract should still be between the employer and the contractor. And then the subcontractor and the contractor must just ensure that the subcontract speaks to the main contract as they intend to pass down certain provisions or have certain direct links. So you might have to amend the main contract to create certain direct links with the subcontractor. But other than that, I do think you should just keep it separate. When VOs are so frequent and the works are so altered that the resulting works is substantially different from what was originally contemplated, how does the contractor react when it feels that it is a frog being cooked slowly and that VOs are being used as a disguised amendment outside the powers of the employer's agent? So it's a difficult question to answer as a right or a wrong answer. I think if there are many VOs, but they are paid, the contractor probably wouldn't have an issue with continuously doing these VOs. However, if you end up with a substantially different scope of work, which might impact various risks that the contractor has got and various obligations that it's got, and might impact on other obligations outside of that project that a contractor might have, then at that stage, you might want to say that the contract that you asked to execute is no longer the contract that you contracted for and terminate on that basis. But Gavin, I think we'll probably have to have a whole day's debate and discussion on that issue. It seems to me to be the perfect matter for a litigation lawyer. Okay, what if the defect picked up by the new owner cannot be fixed? For example, the space left to park the caravan is too small. Okay, so if a defect can't be fixed, and we do sometimes get this issue where there's, let's say we've got a power plant and it's defective, but it's just not economically viable or even possible to correct the defect, and you end up with poorer performance. You can claim the damages portion of your poorer performance. You can claim that instead of then saying that the defects must be rectified. So where it's impossible to ask for specific performance, so where it's impossible to ask for a contractor to fix the defects, it doesn't mean that they're not liable at all. Whatever damages you are then suffering from that, you can claim from the contractor. So you might say, okay, well, we'll have to leave the defect until it fails completely, and at that stage we'll completely redo it. Or the contractor might say that they're going to break something down and build it again at their own cost. But if it's impossible, then you can still claim damages. Diana, one for you. Yesterday we spoke about letters of appointment as not being binding contracts.
So letters of appointment or letters of intent must, as we've discussed, must be clear in terms of the wording. So if there's not an express term in the letter of appointment or letter of intent, then it can definitely constitute a binding and enforceable contract between parties. So if there's wording that expressly states that this contract or this letter does not constitute an agreement between the parties, in that instance, obviously, then there isn't an agreement. And it's subject to conditions such as that a formal agreement needs to be signed. Then it should be clear that that letter does not constitute a formal agreement between the parties.
Okay, so another one is a contractor has not performed up to date, but is claiming more money in order to finish the work. What practically is an effective way to approach the matter in your experience? And this happens a lot. So obviously, as an employer, you have your interim payment certificates, but you want to keep them as close as possible to the actual value of the works done as it progresses. However, it does happen that a contractor comes to you and says, oh, I don't have money, I need more money, please give me more money, because sometimes 20% of the work is done in the first 5 months and then 80% is done in the next 2 months. So it's not always that the increment of work done is going to assist the contractor with proper cash flow for the project. So in my experience, that is exactly why we have performance bonds. So you can give advance payments and have an advance payment bond for that, or you can certify interim payments to assist them to complete the project. But then you must be sure that if they then don't finish the project once everything is done, or there's issues with the project and they've received all the money already, that you can claw some of that back, or at least all of that back, through a performance bond. And this is really just a commercial decision. It's what's going to mostly benefit the project. So obviously, if you don't certify those payments and the contractor doesn't do the work, there's a repudiation, you can always terminate. But I found that employers have to look very hard and weigh up the benefits and the costs of having the existing contractor terminated and getting a new contractor versus taking the risk of helping the existing contractor out. Okay, so if there are no more questions, then I want to say,
what is to happen with the main contractor?
What's to happen where the main contractor failed to submit a VO before completion of the project and the subcontractor has performed in terms of that late VO? Who is liable to pay the subcontractor for the work done? So I think that's very difficult because a lot will depend on the terms of the contract there. So if you are doing work without having received a VO, technically you are not entitled to be paid for that work, not even on an unjustified enrichment claim. Where a VO was given orally but not yet issued formally, that might entitle you to payment still, depending on what the contract terms say. But ultimately, what would happen practically is your subcontractor is going to claim from the contractor for this VO, and you will just have to pass that on to the contractor. And if the to the employer, if the employer rejects it on the basis that a VO wasn't issued, then I would think similarly you will reject the claim from the subcontractor on the basis that a VO wasn't issued. If a contractor terminates a contract due to the employer's default, however, the employer refuses to accept termination or confirm that termination has happened, I'm assuming the question is whether termination has then happened and does not take over the property. What must happen? At what point can the guarantees be cancelled? Okay, so I actually had a similar issue quite a while back where there was a dispute and my client wanted to give site back and the employer didn't want to take site back, and my client didn't want to just leave the site because he didn't want to be liable for damages, theft, losses, safety, etc. And so, again, it was very much a commercial decision. So I don't think that an employer is entitled to reject a termination. What it can do is it can say that your termination is unlawful, ultimately being a repudiation, and then make an election to reject your repudiation and ask for specific performance. But where you persist with your alleged repudiation and you don't go and terminate the contract. So I think from your perspective, person who wants to hand back the site, as long as you're sure that you've done everything to make the site safe, to make the work safe, etc., you can hand it back to the employer whether or not they accept it back. You can make it safe and leave it and say, I'm off site. But just be careful that you don't have any liabilities other than obviously for whatever termination costs there might be if the dispute goes to court and you're found to have unlawfully terminated. We're currently in court to ask the court to confirm termination because the employer ignores the termination and refuses to take possession of site. Yes, I think that's kind of probably all you can do, is you can ask for either in ADR a third party or for the court to issue a declaratory order. I'm not sure through what process you did that, but I'm assuming it would be an on application, which seems like a decent option to me. All right, guys, we're gonna end that there. Thank you very much for bearing with us and for staying online. We've had really, really good participation. Thank you very much for all the questions. It's always great to engage and debate issues. So I hope you've all learned something or found this to be insightful. And we are planning to have another session that'll go into more details of the specific contracts that you find in the market, as well as a lot more detail about dispute resolution, how it works practically, what to look out for, etc. So look out for that. We hope to see you there as well.